Chevron and the overturning of Chevron, I think it's been, overblown a little bit. And so we have to.
Yes, the news of the ATF's death is greatly exaggerated. We are the Armed Attorneys. Today we are talking about the recent Supreme Court case you've probably already heard about but might not know what it means for guns. That's Loper Bright. We're going to talk about what was Chevron deference, what has the Supreme Court done with this Loper Bright case, and what does it mean for the future of the ATF rulemaking authority and the future of your guns. But before we get started, show your support for the Second Amendment by hitting the like button. And today's episode is brought to you over by our good friends at SDI.
This channel is all about education. With more than 350 million firearms in the U.S., the time has never been better to learn how to become a gunsmith.
Sonoran Desert Institute offers online firearm technology education with hands-on labs and materials shipped right to your door. Course topics range from AR-10, AR-15, or 1911 armor options to shooting sports management, ballistics, gunsmithing, and more.
Get your education and turn your passion for firearms into a successful career. Request more information from SDI today by calling 480-999-4767. Tell them the Armed Attorney sent you, or check our link in the description below, sdi.edu/armed-attorneys. So we're talking about the Loper Bright and the destruction of the Chevron deference standard. We got that news last week. We've heard that part, but there's a little bit more to this because, while we can all report, hey, this thing is gone, but I don't think we've seen a whole lot of answers by way of what does this actually do and mean for us going forward with our fourth branch of government, the administrative state. So that's really what we're going to be talking about today, the new standard by which we're going to be kind of judging these agencies and, in them attempting to rule make. And so I think there's a lot of value here. But to understand it a little bit, we're looking at the Chevron deference. This is where courts would, in the past, they would defer to agencies for ambiguities. Guess what? All these agencies said everything was an ambiguity. So basically, let them write their own rules without a whole lot of oversight. The courts were going to give them deference, allow them to, pass on this kind of stuff. And what we've seen for the past kind of decade is lower courts have not been applying Chevron faithfully because they all knew that this thing was, the goose was cooked.
Right. Okay, so take yourself back to 1984. So what we've got is this two-step test, which is number one, is the statute clear or unclear? If statute is clear, test over. If it is unclear, however, you then defer to the agency's interpretation. Okay, but then like Richard was saying, it's not been faithfully applied because every time it comes up, it makes no sense. And so we actually have all of these other precedents, even Supreme Court precedents, chipping away at Chevron because they're like, well, it doesn't make sense here. It doesn't make sense with big economic decisions. It doesn't make, it is like this Swiss cheese of law that's just been sitting out there. And here comes Loper Bright, which is actually two cases, right?
Yeah. And so it surrounded some fisheries. There are so many government agencies. From what I understand, there's over 400 government agencies. You look at committee heads in the United States Congress, and they can't even get reliable lists of how many government agencies they are. So you got problems right there. But we have all these little agencies, this one related to fisheries. They basically wrote themselves a rule saying, hey, you have to subsidize us observing you $700 a day, for, basically room and board aboard these vessels so
Right.
they could observe fisheries.
You have to let us observe you, and also sometimes we're not going to pay for it.
Right.
Which is crazy.
And so, you don't need to know too much else about the background other than to know gut check. That seems completely egregious. The Supreme Court agreed, and they relied on Chevron deference saying, hey, look, Congress, this thing's and when we say the word ambiguous, and saying, hey, is the law clear or ambiguous? They basically get to say everything's ambiguous. And so really, I don't know how much fallback we have on, hey, Congress specifically delegated these authorities because we've seen what they've done with the ATF. But so this case goes up to the United States Supreme Court. They overrule Chevron, so they get rid of that entire framework, and we get a little bit of restoration towards, hey, guess what? The people we elect make the law, not these administrative agencies.
Right. And so what we've done here is say, actually, the APA, which just love the APA. Anyway, so the APA says that decisions of law, decisions of statutory interpretations must be left to the judiciary. And that makes perfect sense. And the Supreme Court says here, like, all of these machinations about, like, oh, this needs to be left to the experts to do, which I know I've been on my rat poison soapbox before, and I still do. I think we've got some rat poison issues here that I won't get into. But basically, the courts are saying that's not the expertise we're talking about here, because you know who the expert is in interpreting statutes,
The
in interpreting
courts.
the law? The courts. Right, exactly.
So, and before we get into the future of the administrative state and the future of the ATF, we have a new standard under which we're going to start looking at these administrative rules. So, Chevron and the overturning of Chevron, I think it's been, overblown a little bit, and so we have to.
Yes, the news of the ATF's death is greatly exaggerated.
I think we need to take stock and see what standards the courts are going to be applying when looking at agency rulemaking. Agency rulemaking hasn't gone anywhere. The Administrative Procedure Act hasn't gone anywhere. Promulgating rules, that hasn't gone anywhere. And so we have this standard. I'm just going to read it out. When the best reading of the statute is that it delegates discretionary authority to an agency, the role of the reviewing court under the Administrative Procedure Act is to independently interpret the statute and effectuate the will of Congress, subject to constitutional limits, and the court fulfills that role by recognizing the constitutional delegations, fixing the boundaries of the delegated authority, and by ensuring that the agency has engaged in reasoned decision-making within those boundaries. So I'd say, stated simply, has the Congress delegated the authority? If the answer is no, it seems like the analysis should stop. But in the event that they have delegated authority, then we figure out what the bounds of that is, and does this fit inside those bounds?
Right. So, what does this ultimately do to the ATF in its rulemaking capacity that messes with you and me and our firearms? Something, not a lot.
No, I will say promisingly, the Congress has not delegated a whole heck of a lot of authority to the ATF.
That is true. So, I think that we have good news in that I think that our firearm statutes, like Richard just alluded to, they are very clear for the most part. What's on the books federally is pretty darn clear.
Yeah, they say, hey, here's criminal acts. And apart from, investigating potential violations of federal gun crimes that the Congress has provided, the ATF does not have broad authority to say, I'm just trying to think of a ridiculous example. What's a safe gun? If Congress said the ATF shall promulgate rules for firearm safety and what's considered a safe firearm. Well, that would be a real bad time.
Oh my God, that would be a real bad time. But yeah, we don't do that.
No.
We don't do that. That's not how the firearm laws work. So it is good news. It is not earth-shattering news.
No.
I'll say that.
But
not for guns.
No. But check out our friends over at SDI, and we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question and comment for us below. Until next time, we're the Armed Attorneys.